Yes. Now, I'm going to show you a draft. It is going to be on your screens. I will need your help to tell me whether you can see that draft or not. And I want you to keep that draft in mind throughout the session. I want you to keep it in the back of your mind and remember what was where in that draft, although we're going to just take a cursory look at it. And in the end, you're going to answer some questions pertaining to that draft and another draft that I will show you. So even if you've not seen a draft before, even if you've never done drafting before, just look at it once, just see the structure and keep that in mind. Make notes if you have to, but keep that in mind. So let me just share that with you. Give me 1 second. Okay. Can you see it on your screens? Just write in the chat box, please. I will need your constant input. Okay, great. Now, if you can see on your screens, in the very first line that you will see, वहाँ लिखा है in the court of District Judge Delhi, and then suit number, and then plaintiff, defendant, left side पे नाम लिखना है, बीच में verses आएगा, नीचे दूसरा नाम आएगा, plaintiff आएगा, defendant आएगा. Then they've given the caption to the suit, which is suit under sections 134 and 135 of the Trademarks Act, read with section 51 of the Indian Copyright Act for the relief of permanent injunction to restrain passing of infringement of trademark and copyright, delivery of rendition of accounts, etc. Now I understand for those of you जिन्होंने अभी law start किया है, you will not know what these words mean. But just remember broadly, there's somebody who's talking, and I would request you to just mute yourself, please, because we don't want to hear your private conversation. That's it.
Draft की class है ऐसी
Neha, can you mute yourself, please? Thank you. Okay. So आपने ये देखा यहाँ पर bold में underline करके लिखा हुआ है what this suit is. Just remember that. And then you go on to respectfully showeth. Now, respectfully showeth or respectfully showeth, they both mean the same thing. What it exactly is nothing but sort of a respect that you show to the court. How you begin your draft and why you write this is because you're addressing the court. And you have to address the court in the most respectful manner. And this is the archaic manner in which it has been written for the longest of times. And that's why we keep on continuing this practice. We write respectfully showeth or most respectfully showeth or showeth. And then we begin with the facts of the case. Now, we are not going to read all of this. These are paragraphs that you can see. I'm going to share this draft with you at the end of the session, so you can just take your time and you can go through it. But right now, we are just cruising through this. There are different paragraphs, as you can see, which talk about the facts of the case. And then you go on to the end where you're talking about certain legal aspects of the case. We're going to discuss that as we begin with our presentation. And then we go on to the last paragraph, which is the prayer clause. And in the end, we go talking about who has filed the plaint, through whom the plaint has been filed, the place and the date and the verification. So right now, and then we have the affidavit. Right now, I just want you to remember this structure. Okay. I don't want you to get into the intricacies of it. I just want you to keep this in mind that in the beginning, there was the name of the court, the number of the suit, then the name of the parties, versus karke jata hai, then the caption, then respectfully show it, and then the facts of the case. And then in the end, there is a prayer. There is the name of the plaintiff again, the signatures, the advocate's name, and the date and the place and verification. Can you remember that? Can you just write in the chat box? Just keep this in mind. All right. Now I'm going to stop sharing this. This is a sample draft. The reason I'm showing this to you right in the beginning of our session is because I want you to dive right into how a draft looks like. And towards the end of the session, I will expect you to be able to differentiate between a draft and a good draft. What a good draft looks like. You will be able to tell that by the end of the session. So just stay with me, bear with me, and stay focused. All right. So let us begin with our presentation. We are going to talk about drafting pleadings. Now you can see my screens, yes? Just write yes in the chat box. I will ask you questions throughout and you will have to respond either by unmuting yourself or writing in the chat box. Thank you. All right, everybody can see my screen. Now we're talking about drafting pleadings today. We have to understand what pleadings mean, okay? And it is often said that law is a profession of language and writing. Why is it often said that law is a profession of language and writing? Is because everything that you want to tell a judge, everything that you say in a courtroom, everything that you work towards building and eventually looking to succeed or win an argument is on record. It has to be on record, which means it is recorded by the court. It is recorded in your pleadings. It has to be there in the case file. Every party that is involved in a case, you, the opposite party, the judge, have to have the same case file with the same documents, with the same pleadings. You must know how to use the power of language. It can be any language that is deemed to be the official or acceptable language of that particular court. It can be English, it can be Hindi, it can be Gujarati, it can be any other language that that particular court goes by. And you have to be fluent in that language. You have to be fluent in your writing skills. There is no other way around. But there is a marked difference between legal writing and legal drafting, as we will discuss today. So just bear this in mind as well, that law is a profession of language and writing. The agenda, what we're going to cover today is number one, pleadings. What are pleadings? That I'm going to ask you and I'm going to talk about, but I do not want the ratified answers from some books or barracks. We are not going to discuss the legal provisions. We are not going to discuss what the law says exactly. We're just going to understand and just for the utility purpose, what exactly those terms mean, how they are employed in the legal profession. So, very first thing that we're going to do is understand pleadings. Then we are going to talk about the difference between legal writing and legal drafting. There's a marked difference. Just because you write well does not make you a good draftsman. Then you have to prepare for court. How do we do that is also something we will discuss today. Then we will discuss the beginning of a draft, the middle of the draft, and the end of the draft. And in the end, I'm unable to understand who exactly this person is who keeps interrupting me. Who is unmuting themselves and not talking to me? Okay. Done. Found him. All right. And in the end, I'm going to ask you to spot the difference between a draft, I won't say a bad draft, a draft and a good draft. With that, you have to keep the draft that we saw right in the beginning in mind. All right. So, a pleading. Anybody who can tell me what a pleading is? You can just raise your hand, you can unmute yourself, you can write in the chat box. But what is a pleading? We are going to talk about drafting pleadings. There's a marked difference between pleading, conveyancing, and other testamentary documents, wills. When I received your registration forms, I saw a lot of you asking questions about drafting wills and drafting contracts. But drafting pleading is different. It does not entail drafting contracts. It does not entail drafting wills. It is different. Now, Weber has written in the chat box, and very accurately so, that pleadings are suits and written statements. That is true. That is what the CPC says. Pleading is a suit or a written statement. CPC does not define suit. Now, for those of you who are in your first year who just started law, or maybe you're a law student, maybe you are thinking of studying law and you're still in school, a suit is not defined in CPC. CPC is the civil procedure, the code of civil procedure, and that is essentially the Bible of practice on the civil side. So, civil litigation is based on CPC. Anything that we plead before the honorable court, for example, plain WS replication, Yashodhara said, that is also right. Now, suit, even though has not been defined, written statement, replication, all of those terms have not been defined. But you have to keep in mind the very first thing is that whatever a pleading is, it goes in the court. It is a formal statement. You plead, you pray to the court, you ask for a relief, you try to convince the court that whatever you are asking for is liable to be granted, or you are entitled to be granted that relief, and the court has the power to grant you that relief. So when you go to court and you file a formal statement, it is a suit. When you file a case for the first time, you're filing a suit, and that is a pleading. When a case has been filed against you and you're filing a reply to that case, you're filing a written statement, even that is a pleading. The main pleadings are restricted to suit and written statement. And then you have supplementary pleadings, additional pleadings, which can be a reply to reply. It can also be a reply to reply to reply. It can also be a reply to reply to reply to reply. So it can be a replication, it can be a rejoinder, it can be an interlocutory application, it can be anything that is being filed in court for the record of the court. It is a formal statement that is a plea to the court, and it is defined by CPC. It is given in CPC, and it is not conveyancing. So please keep this in mind. Very simply, whatever you file in court is the pleading. But do remember that pleadings are only in civil cases. They're not in criminal cases. Criminal cases do not heavily rely on drafting. All right. Although there are a lot of applications that are filed in criminal cases as well. There are bail applications, there are discharge applications, there are other kinds of applications, petitions for quashing of FIR, so on and so forth. Those are all drafted, but they're not called pleadings. They are dealt with separately. In criminal cases, reliance is placed heavily on the evidence stage, on the stage where the statements of the parties are recorded. The charge sheet, the reports of the police complaint, all of that is prepared by the police. By the time it reaches the magistrate, whatever defense has to be presented by the accused or by somebody against whom the case has been filed, they will either record a statement with the magistrate or they will give something in writing. But criminal cases are not dependent on pleadings. Pleadings are heavily relied on only in civil cases, and that's why you'll find such bulky files. And civil cases go on for years and years because till the time the pleadings are complete, the trial does not begin. Till the time all the written documents that have to be filed by the parties, whether it is a suit or a written statement or anything that is in reply to a reply, etc., whatever the pleading is, till the time all of those pleadings are complete, the issues are not framed. Until the time the issues are not framed, the trial does not begin. Now, are you all following me up until now? When we talk about drafting, we have to understand these terminologies as well. It'll be easier for those of you who've done some internships, who've been to court. Those of you who are in fourth or fifth year, those of you who've studied CPC, it'll be relatively easier. For those of you who are hearing all of those words for the first time, it's all right. You note them down. You try to understand their meaning, not from a dictionary, not from a Google search, but from the statute, from the code. Try to interpret what the code says. So a pleading has to be a document that is filed in the court. It is in a civil case. It is not conveyancing. Conveyancing is something that transfers one property from one person to another. Majorly, conveyancing is pertaining to immovable property. When we are talking about contracts, when we're talking about conveyance deeds or the agreement to sell or the sale deed, so on and so forth, all of those things, they are conveyancing and they have a different approach altogether. When we are talking about drafting, majorly in this session, especially, we are talking about drafting pleadings. We are talking about drafting the documents that go to court for a particular case. We are not going to talk about conveyancing. We're not going to talk about wills. But yes, if you have any specific questions, you can ask me towards the end of the session, but that is not going to be the focus of our session today. So now, as we are done with pleadings, how to draft pleadings is a task. Okay, it is a very big task. It is something that you will take years and years and years to hone. It's a skill that you hone, that you cultivate, that you nurture. But it is different from legal writing. Now, you have on your screen what those differences are, what those bullet points are that I'm going to talk to you about. But if you could just off the top of your head, if you could just tell me what you think legal writing is, and what is what is it that legal writing entails as contrasted with legal drafting. Why do they say that you can be a very good writer? You can draft a lot of articles, and you can draft emails properly, you can draft LinkedIn posts and Instagram posts, but you cannot draft legal documents properly. There's a marked difference between legal writing and legal drafting. So what do you think legal writing actually is? If you could just write in the chat box. Okay, while we wait for the answers, does anybody want to unmute themselves and talk about it? Please remember that the more you participate, the more you discuss this with me, the better it will be for you to grasp what this session is all about, or what you are supposed to take away from this, and how this can add value to your career, to your legal profession. So please participate. Do not worry about being wrong or being seen as somebody who doesn't know something. We're all learning here. This is a safe space, and no question is too stupid to ask. Okay. So just feel free to share your opinions in the chat box, and don't worry about sounding stupid. And the fact that you're here today on a Sunday, when it is probably the first match of India in the World Cup, and you're still here, you're studying, that is wonderful. That itself shows how invested and how serious you are towards your growth. So that in itself is a great feat. Don't worry about anything else. All right. So while I wait for you to chip in with your understanding of what you think legal writing is, and there is no one right or wrong answer. Okay, I'm just telling you my opinion. I'm just sharing what I believe and what I've seen in the profession and what my experience has been like. Legal writing is analysis of facts. It is essentially understanding of the technical aspects of law when you're reading the judgments, when you are reading some reports, some bills, some codes, some statutes, some acts, some amendments. You're reading the policy, you're reading what the law entails, and you are trying to understand it, and you're trying to simplify it for general public. So you're analyzing the facts of a case, you're analyzing what the judgment said, you're analyzing the legal arguments, you're analyzing the technical intricacies and the complexities of that particular case, of that particular document, and you're translating it in a simpler manner for it to reach general public, for everybody to be able to understand it. So, yeah, so Yashodhara has said that legal writing is about stating the law and reiterating it. That is one way to put it, Yashodhara. It is not wrong. It is about stating the law, it is about reiterating the law, and it is majorly done for either research purposes or for general awareness. When you read all of those articles that are talking about different legal developments, when you read legal news in live law, when you read opinions, when you read these various websites talking about blogs and articles and so on and so forth about the legal developments of the country and the world, all of that is legal writing. Is not the document that focuses on what goes in court. Now, before moving on with this, let me warn you, in another 5 to 7 minutes, this meeting will automatically end and then I will start it again. So please rejoin, okay? This was apparently for 40 minutes or something. So this is just a technical issue. And I will restart it. You can come back and join again. So please do that. Now, Yashodhara has said that legal drafting is about writing legal language, but before the court, because the general public cannot comprehend legal language. Gauri has written, legal writing covers broad topics and legal drafting is more specific and technical. Yes. So you both are correct. Uh, just that legal writing, as you said, is not for court. It is for general public. It is for you, as a person who is connected with law in one way or another, even if you've not done law. But you can understand the legal terms, the legal maxims, and you can understand the technical aspects of it, and you can translate it and communicate it to public so everybody understands it, and you are very good at writing. You know how to begin, you know how the middle is, you know how the end is, and you know how to structure your article. You're a good legal writer. Just like in medical journals, you have a lot of articles that translate those complicated medical terms for general people, and you have those opinions, and you have those newsletters and journals, etc. All of that is medical writing. So just like that, we have legal writing, but it is, like Yashodhara very rightly said, it is not for the court. And how well you write has nothing to do with how well you can draft. You can be a very good writer, but you can be a very, very bad draftsman as well. So let's get on to that. Now, what is legal drafting? To be able to draft properly, you don't only have to know the structure, like we saw in the draft that we saw right in the beginning of the session. There was the name of the court, there was the name of the parties, there was a subject matter, and then the most respectfully issue it, and then you had the facts. So it is not just the structure. Structure तो तुम्हें आना ही चाहिए. तुमको कोर्ट के रूल्स पता होने चाहिए, जिस कोर्ट में तुम फाइल करने वाले हो वो डॉक्यूमेंट, उस कोर्ट के क्या रूल्स हैं कि मार्जिन कितना होना चाहिए, टेक्स्ट का फॉन्ट कितना होना चाहिए, वन साइडेड प्रिंटेड होना चाहिए या टू साइडेड होना चाहिए, A4 होना चाहिए या लीगल साइज होना चाहिए पेपर का, कौन सा पेपर यूज करना चाहिए, कहाँ कहाँ सिग्नेचर्स होने चाहिए. All of those things also is something that you have to keep in mind. Then you have to understand what are the material facts. You cannot narrate the entire story as if you're just writing an op-ed or you're just writing an article. You cannot talk like that. You have to only narrate material facts. How do you know what facts are material or not is again going to be based on your understanding of the law and your understanding of how to apply law to the facts. For instance, if I am saying that my trademark has been infringed upon, I do not have to go back to the day when I first thought that I will be starting this business. how my business came into being, how many years, I've thought about it, how much I've struggled. All of those are not going to be material facts. But how did I conceive that particular brand name? Since when I have been using it? How this brand name was unique to the services or the goods that I was providing? And how exactly has it infringed upon, according to me, is something that is going to be a material fact to the case, that is going to help me prepare for the case, that is going to help me persuade the court, that is going to help me find supporting evidence for. So eventually, all of those facts without which the court cannot answer your quest cannot answer your reliefs, cannot answer to what you're praying for, cannot say that, okay, yes, you're right, or no, you're wrong. Anything without which the court cannot grant your relief is a material fact in proper layman's terms. Yes, you will understand it better once you read the law, once you read the Evidence Act, once you understand what exactly these terms mean, what are the material facts. But it has to entail a narration of material facts, which has to be in a chronology, it has to be in a series, it has to be compliant with the law. You have to know which law you are actually applying to the facts of your case, and whether within that stipulation, within that section, within that provision, the court has the power to grant your relief in the facts and circumstances of your case. Like I said, if I say that my trademark has been infringed, which law am I going to invoke to convince the court that my trademark has been infringed? It has to be from the Trademarks Act, which talks about infringing suits, infringement suits. So, trademark infringement has to be proved in accordance with that particular section. If that section says that these are the ingredients that must be present in your case, and they will not say it in those exact terms, I'm just translating it in a simpler, in a more colloquial manner, so you're able to follow what I'm saying. But there are certain conditions that have to be fulfilled. Those ingredients have to be fulfilled, and that has to be shown in your draft. Now, one common thing between legal writing and legal drafting is, in any kind of writing, they always tell you, do not say it, show it. So you do not have to say that this has happened to me. You have to show how it has happened to you. You have to show that you've complied with the law. You fall within those conditions. Those things have happened to you. And that is why this law is applicable to this particular case. And you have complied with the law to file this particular suit. You are within limitation. The court has jurisdiction. You are giving all of those declarations. And you are addressing the court. That is basically what you have to worry about, what you have to be concerned about when you are drafting. Now, within 1 minute, this meeting will come to a close. And that is why what I'm going to do is I'm going to end this meeting and I'm going to start again. You can come back and we will, before moving forward, take up some of your queries, some of your questions on whatever we've covered till now, because I know it's a lot to take in and I need you to be able to participate and ask your questions as well. So I'm going to end this and we're going to come back. All right. Join again, please.